As we mentioned in the Grant of Rights module, patent rights define the scope of the license. Now, keep in mind that patent rights are going to differ from license to license. To help illustrate this point, we'll be looking at two licenses as examples. First is a popular university license. We chose this particular one because it's a unique license that many universities look to when creating their own license. The next license is a standard license. This is one you're likely to see outside of a university setting and is far more rigid in certain areas than the unique license. To start out, we're going to be looking at the License Section 2.1, Grant to Licensee. At first glance, it seems straightforward, but keep in mind that the license may not necessarily include everything you want or need. To get a better understanding of patent rights, let's break it down. The first thing you might notice when reading this section is the fact that some of the words are capitalized. These denote special words in the license. Anytime you see a capitalized letter, that should be an automatic signal to you to look back at section 1.22 to see how the license defines the words in their context. Let's start with the capitalized word invention. An invention could be easily defined as a patented technological solution, a method, a device, or a process. An example could be a powerful new battery, an antenna with superior reception, or an innovative on-screen keyboard. Inventions are going to serve as the building blocks in patent rights. Let's look at the next capitalized term, covering the invention. Covering the invention is a legal technical term that's often used with respects to patents and inventions. Basically, covering the invention means the invention is encompassed by a patent. Sometimes a patent can cover one invention, or the patent can cover many inventions. An example is a patent on a mobile phone. A mobile phone is made up of an antenna, a battery, and a keyboard, among other things. A patent on our new mobile phone would encompass the antenna, the battery, and the keyboard. The next term we'll look at is effective date, or during the term of this agreement. This may not seem important, but the effective date will dictate to you whether or not you could use other patents developed or acquired by the university. Now that we've defined these terms, what implications do these definitions have for an entrepreneur? The primary implication of these patent rights comes into play when dealing with improvements. Improvements are defined as any technology that could be utilized by your patented invention to make it perform better. As an entrepreneur, keep in mind that any future work on technology is owned by the university and not you as the inventor. Many entrepreneurs assume that they will have all the rights to the technology they need, but this is not necessarily true. When looking at the unique license as we described it, improvements are automatically allowed. Basically, if someone invents a new technology that your patent invention could use, you're allowed to use it without renegotiating the license. Using our mobile phone example, if a colleague invents a new antenna, you can include it in your mobile phone. We know this because of two reasons found in the patent rights. First, the antenna is covered by your invention. Your mobile phone invention needed an antenna, and the antenna falls within the patent for the phone. Second, because the effective date said that we have rights not only to the patents encompassed by our invention, we also have rights to future patents acquired by the university that fall within the scope of our invention. Let's compare this to the standard license. In this case, improvements aren't included in the license. Remember that according to the standard license, you only have the right to use the inventions covered by the patents specifically listed in the appendix. For example, if your license with the university is a standard license, and a colleague invents a powerful new battery, you can't automatically include that battery in your mobile phone. The new battery is not covered by your invention because its patent number is not listed in your license. So why don't all licenses include improvements? A university will argue that it takes a lot of money and resources to develop new technology. The university wants to make sure that its future inventions aren't automatically swept into licenses that it has with other inventors. On the other hand, entrepreneurs argue that potential venture capitalists and acquirers aren't going to want increasing licensing fees each time they want to improve their invention. Also, they might be concerned that the university would sell their improvement to a competitor, leaving you and the investors in the dust. While there's no perfect solution to this, keep in mind that a university wins only if you win. A reasonable compromise is to include improvements that are clearly defined for a limited time. For example, you may wish to include battery improvements from your colleague for a period of time, say 3 to 5 years. In return, you could offer to contribute financially to the battery lab on campus. While most entrepreneurs prefer to include improvements, it comes at a cost. We'll discuss this further in a future module on royalties. Patent rights can be confusing to understand, but with the right frame of reference and understanding, you can be sure you're getting what you need, now and in the future, to ensure the success of your invention.